Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann. Shauna Sanford is out today. We very much appreciate your participation here on Power of Attorney. Your feedback and input is what we use to determine what we'll talk about each week. And since so many of you had questions about wills and estates and successions, we're dedicating a two-part series to estate planning and successions. What you need to know about how to plan for your passing and what happens to your estate, whether you've planned or not. We're fortunate to have an authority on estate planning with us today who has literally written a book or books on estate planning and successions. Stay with us because when we return, Attorney Carole Neff joins the show to discuss some of the need-to-knows about wills, living wills, and related estate planning matters.
That one-on-one relationship with an adult is so important. If every day somebody is touching base with somebody and then they get to spend some time each week with that person, there's a relationship that develops. And all the communities and school services are really designed to create that one-on-one relationship.
This school has taught me so much to be the best that I can be. They never give up on me. They never give up on anyone here.
Hello everyone and welcome back to the show. Today we're talking about wills, living wills, and other estate planning matters. We're excited to welcome attorney and author Carole Neff to the program to help us in understanding what you need to know about this important area of the law. Carole is a partner at the New Orleans law firm of Sessions, Fishman, Nathan and Israel, LLC, where she heads the Estate Planning and Estate Administration Department. Carole is board certified by the Louisiana State Bar Association, and she's co-author of this 3-volume treatise on Louisiana estate planning, which we'll show you in a bit. Oh, there it is right there. So it's important to know that she has also served as president of the New Orleans Estate Planning Council and is active and serves on the boards and committees of many other civic and professional organizations. Carole has received numerous awards, including Woman of the Year by New Orleans City Business and the Partners in Justice Award by the New Orleans Jewish Service Corps. Thanks again for joining us, Carole. We've got a lot of information to cover here, so what do you say we just jump right in?
That sounds great.
Okay. All right, well, estate planning, I think to most people that sounds like something rich people do when they've got a big estate, a big mansion out there like Downton Abbey. Tell us, what is estate planning?
Well, estate planning is really something that is something everybody really should consider doing, and it is not just for the rich, and it's not just about taxes. As a matter of fact, most of what estate planning involves is making arrangements so that when you die, your assets go to the right people, the people you want it to go to, and in the right way. So the planning side of it is getting your will together, and another thing that happens in planning is to plan for the possibility of our aging and becoming incapacitated, and powers of attorney are what we do in that area of planning.
Right. So estate planning is in more basic terms, it's just getting yourself together so people know what to do with your property when you pass away. And also, if you want to take that ounce of prevention, prepare in the event you have an illness or maybe even an accident that incapacitates you, so people will know what you want done with your estate while you're still living but incapacitated.
Correct. And also, as the population ages, we reach levels of incapacity when we age where we need others to assist in the management of our affairs. So part of estate planning is getting those documents put together so we have the right people in place.
And it makes good sense that while you hopefully are in a good place and you can think about what you'd like to have done with your estate, do it now rather than if you're incapacitated or disoriented with an illness. You want to take care of that now, so down the road people will know what you would like done with your estate.
Correct, and the right people are put in place as well, because if you don't make that kind of planning, then it could end up that a court picks someone and it might be the last person you would have wanted to be in that position.
In other words, you can name somebody to manage your estate, either when you're incapacitated and for after you've passed away.
Exactly, yes, indeed.
Well, we've got a lot to get to, so let's dig in a little deeper. So, do people need lawyers to do estate planning?
Well, I'm a lawyer, and obviously, you know, I'm going to say yes to that question. But aside from my own personal prejudices about the importance of using a lawyer, I'd even go a step further and say that it needs to be a lawyer that has some level of expertise.
Sure.
In planning estates, yes.
And certainly if you've got a complicated estate, or you've got a lot of things that you need to have done and you want to be certain they're done properly, an experienced lawyer who practices in your area of the law is the obvious choice. And let me say, because that's not something that I do. My area is really personal injury and some related matters. My advice to the viewers is you want to get a lawyer to help you with this. What if you really don't make much money? How much, you know, suppose you basically have a home, you have contents in your home, you're not well off. Is it going to set you back a lot of money to get the help of an experienced, qualified lawyer?
It may or it may not. Most attorneys that specialize in this area of practice bill on an hourly basis. So the more complicated, obviously, the more time a lawyer would have to put into it, but also most of us use paraprofessionals, paralegals, who are billed at lower hourly rates. Some lawyers bill on a flat fee basis, but the majority of people that specialize in the estate planning field bill on an hourly basis. But sometimes people think they don't have a lot of assets. They have their home, they have a bank account, they have their household contents, but they might forget that there's a 401k with work or an IRA, or they may forget that there might be a life insurance policy.
Very interesting.
And sometimes they don't take into consideration that they have more assets than they thought they did.
And to get to your point, a lot of times what you've done, that wheel's been invented. There's sort of the main things that people ought to do with their estate. It's fairly standard. Someone in your position who does what you do is able to make sure it's all done right, but you can rely on paralegals and other people to prepare the basic paperwork, get the basic information, and then you make sure it's done properly, and you fine-tune it or finish it up. Is that a fair statement?
Correct, and our goal there is to keep the cost down for the client. We know that that's sort of, it can be a deterrent to get people to do their planning, so we really try to make it as reasonably and cost-effective as possible.
Let's talk further then. So a big part of estate planning is having a will. In Louisiana, do you even need to have a will?
The vast majority of people need to have a will, whether they live in Louisiana or any other place. But when you die without a will, the state of Louisiana effectively writes your will for you.
In other words, you're not required to have a will by law, but it's just common sense, and it's a no-brainer that people should have a will, correct?
I would agree with that.
Okay. And even if you don't have a big estate. Well, you hear a lot of talk these days about living wills and use of living wills. How's that different from a will like a last will and testament?
It's very confusing for people because the terminology is so close. A will is the document that sets forth how your estate is going to be distributed when you pass away. A living will is actually the document that some people think of as the pull the plug document. That's the document that you sign when you're competent, that says that if you are in a permanent vegetative state and two doctors say that you're never going to come out of this coma, that you don't want to be on life support. That's a living will, and it's limited to just that situation.
Okay. Now, just let's talk about wills. And they say last will and testament and a will for after you die. Same document, right?
It's the same thing.
Okay. What are some of the main things that you really need to have in a will for it to be a valid and enforceable document after you pass away?
Well, first of all, there are only two forms of wills in Louisiana that are valid. One is one that somebody could write themselves, but it needs to be entirely handwritten, dated, and signed by the person writing the will to be a valid form of will.
Right.
So a person in Louisiana, as in most other states, I think probably all other states, can write their own will, but they can't type it off of the computer. It has to be entirely handwritten, dated, and signed by them. That's a valid form of will.
And just to add to that, and do they still call it an holographic will? That's
they
the term,
do indeed.
fancy
that is.
law term I learned.
Yes.
If you have somebody help you write it all out for you, and they even write it in their handwriting, but then you put your signature and you date it and you do everything else, that's not good enough.
It's not good enough, and it will not be honored as a will. It'll be as if you wrote nothing.
Okay. And then the other type of will?
The other type of will is one that a lawyer prepares. In Louisiana, it's called a notarial will, and it's a document that is typewritten, and it's signed by the person who is writing the will. It's a person we call a testator if it's a man, a testatrix if it's a woman. It's signed by the testator on each and every page, and then at the end, and it's signed before a notary public and 2 witnesses. Everybody has to be present when the document is being executed. And there's a special paragraph at the end, this very important clause at the end that states that says that the testator said, this is my will, that the witnesses were present, that everybody watched everybody else signing, that the notary was there. And without that special clause, the document may be invalid.
So that's very important. And a big reason for that is you don't want people to pass off phony wills.
Exactly, and then you don't want them substituting pages, which is why there's a requirement that it be signed on every page.
All right, well, we got a lot to cover here. What about trusts? Define what is a trust, and how do trusts fit into this?
Well, trusts, there are all kinds of trusts, but the trust that is most commonly used with wills is a trust that's written into the will that is a management tool. So I want to leave something to my child, but my child is too young to manage it herself. So I create a trust inside the will, and I name somebody else, who we call a trustee, who's going to manage the assets inherited by my child. So it's a management tool, and it can be written into the will itself.
It prevents the child from taking the inheritance and going and blowing it at the casino, or basically getting rid of it all too quick and then there'll be nothing left.
And so, exactly, and so other people can't take advantage of them. They can't pull the assets out of the trust because the child doesn't have the power.
And then there's this can't lose investment they got to make, and of course they lose and lose investment.
Yeah, so we use trusts a lot in the wills that we do, and the vast majority of our wills have trusts in them for a variety of purposes.
And they even have some tax ramifications, or is that something that trusts don't have that much to do with?
Well, trusts do have tax ramifications, and there is tax planning that goes into that too.
All right, we're real short on time here. What is forced heirship, and how does that relate to when you have children and what you want to do with your will?
Well, Louisiana is the only state that has forced heirship. We got our law from French and Spanish sources, and Louisiana does have forced heirship, although it's changed over the years. And the forced heirship concept is that a parent must leave a certain portion of his estate to a forced heir, and who the forced heirs will be descendants of that individual who are under the age of 24 when the parent dies. So it'd be a child 23 and under, or a child of any age who has a permanent incapacity to the degree that that child can't take care of themselves.
Can't support themselves.
Yes, so that's a forced heir. So when someone writes a will, they have to include the forced heir, and that's another way that we use trusts a lot.
Excellent, excellent. Well, we've got so much more ground to cover. However, we've run out of time for this segment, but stay with us, because when we come back, we'll answer some interesting viewer questions right on the same topic.
My life is full of statistics. Thing is, I could have dropped out of school and become one myself, but I didn't, because I had people that believed in me. Here's another statistic. 7,000 students drop out every school day. That's one every 26 seconds. It's time that students know that we believe in them.
Inspire a student and share your message of support at boostup.org.
Welcome back. We're wrapping up the first episode of a two-part series on estate planning and successions with our attorney guest, Carole Neff. We've reached the part of the show where we answer your questions on air. So let's get right to it. Someone named Brady wrote in and says, what happens if I lose my will? So someone dies and they can't find the will.
That can be a problem. And we need the original will to present to the court, but the law does allow us in certain circumstances to use a copy instead of the original, but you have to be able to prove that the reason we don't have the original is not that the testator himself tore it up or burned it up or tossed it out, but that it was lost in the flood, or we just can't find it, or the attorney that was storing it died and we can't reach the family of that attorney, so here's a copy. So the court will allow a copy in lieu of the original, but it's very important to have the original available.
So the moral of the story is, with your will and any of your important documents, you want to make certain that you keep it in a very secure place. It might not have to be a safety deposit box, but someplace where you and your trusted family, any trusted family member or members knows where to find it.
And has access to it.
And has access. Is it a good idea to make copies of the original just in case something happens to the original?
It is a good idea to make copies of the original.
And store that somewhere else, because if there's a home fire and everything in your house is gone,
exactly, or there's another Katrina and people have their original wills in their safety deposit boxes.
All right, let's see here. Teresa says, can you voice record your last will and testament? That's an interesting question.
No, that is not a valid form of will in the state of Louisiana. It has
so even if you, I cut you off, I'm sorry.
That's okay.
So you always want to honor the last will, the will of the person who passed away, even if they videotape themselves saying, this is what I want to have happen to my estate, unless they do a proper will, either the holographic type that's all in your own hand and dated, or the type that's done in front of a notary public. Without that, then the law decides exactly how everything is supposed to be divided
up. The Louisiana Civil Code will do it and will completely disregard this voice recording.
Well, there's a lot of people out there without wills, and despite best intentions, they might never get around to making a will. What does the law do with the estate of someone who has passed away and no will can be found?
Well, the vast majority of our estates, unfortunately, are those that people die without wills. And the Louisiana law does spell out who's supposed to get it and who's supposed to control it. But and it's going to depend upon who the relatives are, who are the closest relatives. Does this deceased person have a surviving spouse? Does the deceased person have children? When someone dies without a will and has children, the children inherit everything equally.
Whether they're married or not?
Whether they're married or not.
Okay.
If the deceased person has a spouse, the surviving spouse gets an automatic right to use the assets of the deceased person as long as those assets are what we call community property, created during the marriage, were not inherited by the deceased person. So the surviving spouse has certain protections, but they're very, very limited.
And that rule applies whether or not the person who's passed away, the decedent, has children?
The rule that would allow a surviving spouse to have the automatic use of the deceased spouse's assets is whether or not that person has children. If the decedent doesn't have children at all and has all community property, then the surviving spouse actually is going to inherit the deceased person's assets.
So an example is husband and wife are married 50 years. One spouse passes away. If they're a Louisiana couple and community property applies, then, and community property would apply unless you made special legal steps to avoid that, then the surviving spouse, the widow or widower, lives in the home that was the home of both of them, and gets to enjoy that home and maybe the family automobile and even the furniture and whatnot. Correct?
If it's community property, yes. The limitation, though, is that surviving spouse who has something, and what the word we're looking for here is usufruct. It's a Louisiana term. Use and
fancy law term.
Yes, it is. A Louisiana
fancy. Enjoyment of the estate.
Exactly, but that surviving spouse doesn't have the power to sell the house as a usufructuary.
Right, so you don't get to sell contents of the house. You don't get to borrow money on the house. Or maybe
not without the consent of those who actually inherited.
That are due to inherit.
And those would be the children, if they're children, or even grandchildren if a child died before the parent and was survived by children of his own. So this automatic right that a surviving spouse has is good to have, but very limited in scope. Limited in powers, and also if the surviving spouse remarries, those rights terminate at that time.
And that's by operational law. In other words, that's not something you've written in your will. That's just what the law says if there is no will.
That is correct.
Okay. And if you have grandchildren who, and maybe you outlive your children, but you have grandchildren who are under the age of 24, they're forced heirs as well?
Well, we get a little confused when we talk about forced heirship versus dying without a will. When somebody dies without a will, it's irrelevant who the forced heirs are, because children are going to inherit automatically no matter what their ages are. But when people write wills, then they have to be mindful of whether or not they have forced heirs. Grandchildren are not always forced heirs.
The parents have to be...
Certain grandchildren are going to be forced heirs. So a grandchild whose parent died before him and has a permanent disability is going to be the grandparent's forced heir. Okay. Or if there's a very young child, let's say 20 years old, who dies and has a child, if the child would have been a forced heir and dies before the parent, then the child's child, the grandchild, will be a forced heir of the grandparent. I mean, so there are limited circumstances in which a grandchild would be a forced heir.
Well, and let's get back to written wills, because we're short on time, but there's so much to cover. What happens if you have a will but you don't update or amend it when another child is born, or if someone named in your will has passed away before you die and the will's not changed?
Well, those are really two different questions. So if the will was written before another child was born, and there's no provision in the will that says I leave it to my children who survived me, instead it says I leave it to my daughter and my son Jane and Joe, and then
here comes Susie.
Here comes Susie. Okay, Susie comes along and Susie's not named. If she's not named, or there's not a general reference to a possibility of another child, then if Susie's a forced heir under the age of 24, Susie can come in and claim what we call the forced portion, but that's not going to be equal in that scenario to what the other siblings have received.
So if parents left everything to son and daughter, and then daughter number 2 is born before that person passes away, then maybe the 2 children get everything minus a forced portion.
Correct, and the 2 children will get more than what the forced heir receives.
It does not invalidate the will?
It will not invalidate the will, but it will reduce what other people are going to receive to protect the rights of that forced heir.
Okay, all right. Let's see. Susan writes, can you write your will to exclude your spouse?
Yes, you can. Yes, you can. So if you don't want your spouse to have a usufruct over your assets, you can leave assets outright to your children or your favorite charity or your best friend. You don't have to provide for your spouse.
Someone else wrote with a question, can someone else change your will?
No, that is not allowed. Only you have the power to change your will.
Right. Patrick writes, can I write my will with conditions like Susan is to receive the house only if she graduates from college?
Well, there's sort of a yes and a no to that answer, or it depends. We have to know who is entitled to inherit at the moment of the death of the deceased person. So if we're delaying for years to find out if Susan's going to graduate from college or not, that would not be a valid condition. On the other hand, if there was a trust that says we're going to put the house in the trust and the trust is going to be turned over to Susan when she graduates, that would really be okay, so that if she never graduates, then the trust will still own the house. So there are ways to respond to that and get what the person wants.
If you're not a lawyer who specializes in this area and you try and write your will to do all this, there's a good chance it's not going to be accomplished if it's a special condition you want like that. But
it takes some knowledge
and training of a lawyer who does estate planning, you can take steps to make a lot of those conditions happen, or at least
we want to hear what our client's goals are, and then our job is to write it so that those goals are able to be carried out as best as possible.
All right, well, to sum up a little bit, if you have no will, the law says that it dictates where your estate goes, correct?
Yep.
And typically speaking, let's say your average married person who's still married when he dies and they have young children without a will, the children would inherit everything.
Correct.
And the surviving wife or surviving spouse would be allowed the use and enjoyment of whatever's in the estate.
That's correct. Now the limitation, though, is that with these minor children, let's say the surviving spouse finds that it's time to sell the house, and since husband died without a will, she doesn't have that power. She'd have to go to court and start what's called a tutorship proceeding For her minor children, she'd have to get the court to appoint her as tutrix. She'd have to get the court to approve the sale of the house. So it adds a lot of complexity.
And all that complexity is really there to make sure that the young children don't get taken advantage of and have their assets sold out from under their feet, and then there's cash left over, and then the cash is burned up before the children reach 18.
Right, so that's why the law is written that way, to protect the rights of the children. But when somebody thinks about that in advance and writes a will, he can put a trust in the will for the benefit of the children. He can name his spouse as trustee to give her powers that she would not otherwise have. He can name somebody else if he doesn't want his spouse to be the trustee. He can name someone to follow the spouse if the spouse can't do it forever.
We're almost out of time, but what happens if somebody moves to Louisiana and they came from a state that doesn't have forced heirship and they have a written will, and they establish residence here? They're not just passing through. Do the same laws on successions and estates apply to that new resident of Louisiana?
It would. It would. It depends on the domicile of the deceased person. Where were you living when you died? And it's the law of that domicile that dictates how your estate is to be distributed and what law applies.
Wow, well, you've given us so much helpful information, and we're very grateful to you for being here. The only problem is we've run out of time. So, but we're going to have you back on the very next episode talking about successions and actually talking about what happens to the estate after someone has passed away. So stay with us. Remember to visit the show online at johnredmannpoa.com, where you can watch this and other episodes, and you can find more information about what we've talked about today. Of course, you can find us on Facebook, follow us on Twitter. We'd love to hear from you, so keep sending in those questions. Thank you so much, and we will see you next time on John Redmann, Power of Attorney.